Welcome to Critical Debrief. Today we are very fortunate to have an exclusive interview with Associate Justice, the Honorable Stephen Breyer of the United States Supreme Court. Justice Breyer was nominated by President Clinton in 1994. Justice Breyer, thank you for being here today.
Thank you.
What about this notion that the court should not be too far ahead or too far behind the court of public opinion?
This is a law professor and commentator's notion. I would say it is not a judge's notion. The ideal for a judge is, what does public opinion matter in the case? Zero.
Now, in the years that you have been on the court, has there ever been a case where, we better hear it over again?
Yes.
We better hear it over again. We better start all over again and hear oral argument again.
Yes, we just did that this term.
And which case was that?
I think it was a case involving the Alien Tort Statute, which is it's an interesting statute. It's passed in 1790, saying that a person can sue anyone. Anyone can come into a federal court and sue anyone in the world who has harmed him by violating international law. The court, thinking they'd like to hear some more argument on it, set it for re-argument in the fall.
Wasn't Brown v. Board of Ed re-argued?
Yes, it was. Many important cases have been re-argued. That's right. Our Roe v. Wade, I think, was re-argued.
Without reference to a specific case, how do you apply your approach to constitutional interpretation when it comes to something like campaign finance reform?
The people who think that you cannot regulate campaign finance, the judges who think that, say that this is about free speech. Why? It's money, it's not speech. But they say, correctly, I think, you cannot conduct a political campaign without money. The whole point of the First Amendment is to get different ideas across. And you say, but my goodness, it's too much money. You say, aha, you're going to get into the business of deciding what's too much.
And yet you say...
I don't believe... I say it's a good argument, but I don't accept it. And the reason I don't accept it is because I think the purpose of that First Amendment, above all, one of the major purposes, is to give every citizen of the United States who's voting a chance to participate in a debate. And the more ideas that get into that debate, the better. And you shouldn't have so much money spent by a handful of people to promote one point of view that they drown out the others.
Is there a particular myth or series of myths about your work and that of the court in which you serve?
Yes. Well, I'll put it this way. I heard Senator Reid talk about a case which you and many people here will know, called Bush versus Gore. I dissented in that case. Well, it was 5-4. It was a case that certainly affected a lot of people. At least half the country thought it was wrong. And since it was 5-4, somebody must have been wrong. I mean, we're human. But he said this is Senator Reid, who I suspect thinks it was decided wrongly. He said the most remarkable thing about that case is something that's rarely remarked. There were no riots. There were no guns in the street. They didn't start killing each other. And Harry Reid said that is a national treasure. And the Chief Justice of Ghana, a woman, wanted to know, when she's in my office, she's trying to promote human rights there. She says, how did you get that? And I have to tell her, it's not magic. It's 200 years of history. And we have 308 million people. We have 1 billion points of view. And they've all decided to solve their differences under law. That is a miracle. It is a miracle. And it is a tradition that's grown up gradually over time. So I think it's not magic, which is the myth that it is. It's just like the air. It just comes there. It is teaching, learning, paying attention, and being willing to work in your community. And that's what you're doing in part in this program, and that's why I think it's a very good thing.
The reputation and eloquence of Justice Breyer is no myth. This is Critical Debrief. Thank you, Justice Breyer.